If you possess skill, training, or, knowledge far beyond what the average roughly has, does the law actually require you to use it?
Mm.
And if you fail to use that superior ability, does that automatically make you negligent? This isn't just theory, right? This kind of conflict, this clash between the standard objective rule of negligence and someone's actual, maybe superior skill. It's really at the heart of countless liability cases. Welcome to the Deep Dive. Today we're digging into the legal details to answer a very practical question. When a professional, maybe like a commercial truck driver, causes an accident, how are they judged? Is it by the standard of just any driver or by the standard of their specialized trade?
That's exactly the mission. And to get you up to speed quickly, we need to tackle this in, let's say, 3 steps. First, we have to really nail down the baseline. Ordinary care, what does that even mean? Second, we'll look at 2 key rules that kind of adjust that baseline, the superior knowledge rule and the profession or trade principle. And finally, we'll pull it all together by analyzing a really important case, Dakter v. Cavallino, which applied these rules directly to a truck driver.
Okay, let's unpack this, starting right at the foundation. Before we even get into specialized skills, what's the basic black-letter rule for negligence? The one that applies to, well, everyone.
Right. The general rule is pretty straightforward on its face. Negligence is defined as the failure to exercise ordinary care under the circumstances. But the crucial thing for you to grasp is that this is an objective standard. The law doesn't really care if the person felt they were being careful or if they were having an off day. What matters is the level of care that the great mass of mankind would ordinarily exercise. Or, put more simply, it's the care of a reasonable actor considering the specific situation they were in.
Okay, that makes sense for, the average person. But here's where it gets tricky, I think. How does that objective standard deal with subjective ability? Like if someone genuinely has knowledge or skills that are way beyond the ordinary person, maybe they're a certified expert in something, does that objective standard automatically get, bumped up to match their skill level? Is it a higher standard for them?
And that's a critical point. The standard of care itself always remains ordinary care. But, and this is a big but, how the law applies that standard changes quite a bit. This is where the superior knowledge rule comes in. The general rule on superior knowledge basically says that an actor's superior skills or special knowledge are considered part of the circumstances that you have to take into account when figuring out if they acted reasonably. The restatement of torts puts it clearly. If an actor has skills or knowledge that exceed those possessed by most others, these skills or knowledge are circumstances to be taken into account.
Okay, so why the sort of legal distinction there? If a reasonable person with that extra skill would naturally be more careful than someone without it, why doesn't the law just say it's a higher standard? Seems simpler.
That's really the core of the legal reasoning, and it's vital for keeping tort law consistent. You see, if the standard itself changed, you'd end up with different tiers of care depending on the individual. That would kind of undermine the whole point of an objective standard. So the actor still only has to meet ordinary care. But for that specific actor, what ordinary care means includes using all the relevant special knowledge they actually have to deal with risks they should recognize. Think of it like this. The legal ruler, the standard stays the same length, but the mark you're expected to reach on that ruler moves up if you have greater capabilities.
Right. Fixed standard, variable performance based on what you know. Got it. That's a key takeaway.
Yep.
Okay, now let's shift gears slightly. From that internal, personal knowledge, what about skills someone gets through their job? Does the standard change if the knowledge comes from an occupation, not just personal expertise? This brings us to the profession or trade principle.
Exactly. This principle kicks in when someone is working in an occupation that requires specialized training or skill. Under this rule, they have to exercise the knowledge and skill that a reasonable member of that same profession or trade would use in similar circumstances. And it's not just for, doctors and lawyers. The rule covers any occupation that needs acquired learning and aptitude developed by special training and experience. Legal sources give examples from, say, a chiropractor, like in the Kirkman case, all the way to trades like plumbers, carpenters, even blacksmiths back in the day. The basic idea is if you present yourself as competent in a trade, you'll be judged by the standards of that trade.
Let's try to clarify that difference then. Is superior knowledge kind of like being naturally gifted or having learned something specific on your own, whereas the profession trade principle is more about having, say, a formal license or degree for a job?
That's a pretty good way to think about it, yeah. Superior knowledge is about the individual's actual abilities or learning, whatever the source. Profession trade is tied to the societal expectations for a particular job or occupation. And importantly, these two ideas often overlap. A reasonable person is expected to use any relevant special knowledge they have, whether it's personal or from their job. In fact, if you're a professional and you happen to know more than the average person in your own field, maybe you're a doctor who's read cutting-edge research, others haven't, you're actually held to using that higher level of knowledge you possess. The law basically says, bring your full capabilities to the table when it comes to avoiding harm to others.
Okay, the theory seems clear. Let's
Yeah.
see how this actually played out in court, especially with that tricky distinction in a real-world case involving a commercial truck driver. Let's analyze Dakter v. Cavallino. Start us off with the key facts. What happened here?
Right, so Dakter involved a pretty serious collision. It was between a regular passenger car driven by Mr. Dakter and a very large vehicle, a 65-foot semi-trailer truck. The truck was operated by the defendant, Dale Cavallino, and crucially, he was a professional driver. He held a commercial driver's license, a CDL. There was a 10-day trial, and the jury found Cavallino was 65% responsible, causally negligent for the accident. The appeal, though, wasn't about the accident facts themselves. It focused entirely on one specific instruction given to the jury.
Hold on. If the basic rule is ordinary care, why did Cavallino even think he could argue his professional license and training shouldn't count? That seems, well, odd, especially driving such a big rig.
Well, Cavallino's argument was essentially that driving is driving regardless of the vehicle size or license. He claimed the instruction telling the jury to judge him based on the care, skill, and judgment of a reasonable semi-truck driver was wrong. He argued that this created a heightened standard of care, something he felt should only apply in, say, professional malpractice cases like for doctors, not for a traffic accident.
Okay, so that was his argument. What was the core legal issue the appeals court had to decide then?
The precise legal issue was, did that specific jury instruction, the one holding him to the standard of a reasonable semi-truck driver, misstate the law and unfairly prejudice him, therefore requiring a new trial?
Got it. And what rule did the court actually apply to answer that question?
The court was quite firm. It stated that both the superior knowledge rule and the profession or trade principle apply to professional semi-trailer truck drivers. So while the fundamental standard of care is still ordinary care, the circumstances the jury has to consider definitely include the fact that the driver is a professional with specialized qualifications.
Okay, that's the rule they applied.
Yeah.
What was the court's reasoning? How did they connect the dots in their analysis?
Their reasoning was pretty logical. They said, look, the skills and knowledge needed to safely handle a 65-foot semi-truck just aren't things the average person possesses. It's not part of the ordinary equipment of a reasonable person. Operating a vehicle like that requires specific, acquired learning, special training, and passing tests, things quite different from driving a standard car. And to back this up, the court didn't just use common sense. They pointed directly to federal regulations, the rules detailing what knowledge someone needs to even get a CDL. These regulations cover things like perceiving hazards, managing speed, handling extreme conditions, knowing about safety-related truck parts, things an ordinary driver wouldn't necessarily know in detail. So the court concluded that since the law itself demands this special competence to get the license, judging the driver's actions has to be done by comparing them to a person with that required special competence.
So the CDL itself changes the circumstances lens for the jury, even if the standard name stays the same. Okay, and the final verdict, the conclusion.
The conclusion was clear. The truck driver negligence instruction was correct. It properly told the jury to factor in the defendant's special knowledge and skill as part of the circumstances defining ordinary care for him. It wasn't a misstatement of the law, it wasn't misleading, and so the judgment finding Cavallino negligent was upheld.
That case really nails down the duty for professional roles. But let's circle back to that first principle we talked about, the superior knowledge rule for personal, maybe non-job related skills. Let's try a more visceral hypothetical to make it stick. Imagine an expert construction inspector, right? Someone who really knows structural defects. He buys an old house for himself. While he's, say, painting a basement wall, he spots some minor stress fractures, things an ordinary homeowner would totally miss. But he, with his expert eye, sees them. He kind of shrugs it off, thinks, it's probably fine for now, ignores them. A week later, that part of the structure fails, collapses, and injures a guest he has over for dinner. What then?
Oh, that's a perfect, almost textbook example of the superior knowledge rule biting someone. In that situation, the inspector is absolutely negligent. The law demands that he, as an individual, use the superior knowledge he actually had. He can't just fall back and say, well, an ordinary homeowner wouldn't have known. He knew. Because of his specific superior knowledge about structures, he was required to recognize the risk involved in doing nothing about those fractures. The reasonable person standard, when applied to him, includes his specialized structural expertise. His failure to act becomes a clear breach of ordinary care under his circumstances. He's not judged as just a reasonable painter in that moment. He's judged as a reasonable painter who also happens to be a structural expert.
That really drives it home. The duty follows the knowledge wherever it comes from, job or just personal expertise. Okay, so wrapping this all together, what does this mean for you, the listener, when you're trying to spot these issues? Can you give us a quick step-by-step checklist to diagnose these negligent situations?
Absolutely. Here's a practical framework for analyzing duty of care when skills or knowledge might be involved. Step-by-step diagnostic checklist. 1. Baseline check. Always start with the basic objective standard. Ordinary care. Ask, what would the great mass of mankind, the average reasonable person, do in these exact circumstances? 2. Special circumstance check. Then ask, does the person involved, the actor, have any special training, a license, or maybe personal knowledge or skills that are clearly superior to the general public? If the answer is no, you just stick with the basic reasonable person standard from step 1. 3. Superior knowledge test. If the answer to 2 is yes, and the skill is more personal or general, ask, did this person fail to use the specialized knowledge or skill they actually possess to either recognize a risk or avoid a harm related to that skill? This applies to anything superior intelligence, specific experience, unique personal learning. 4. Profession trade test. Alternatively, if the answer to 2 was yes because of their job and the injury happened while they were doing that job, then you apply the standard of a reasonable member of that specific profession or trade. Think. The reasonable semi-truck driver, the reasonable doctor, the reasonable electrician, whatever fits. 5. Final assessment. So if either Rule 3, superior knowledge, or Rule 4, profession trade applies, remember this. The definition of what ordinary care requires for that person changes. It includes using those special skills or knowledge. The legal standard is still called ordinary care, but the actual level of expected conduct, the performance bar, rises to meet that person's superior ability.
That is a fantastic deep dive into how skill shapes duty. We've clearly shown that, in the law's view, having superior ability doesn't technically create a new standard of care, but it absolutely raises the bar for what ordinary care demands you actually do given your specific circumstances and knowledge. The lesson from Dakter is loud and clear. If you have the specialized knowledge, you have a specialized duty that comes with it. Thank you for breaking down those sources for us. We really hope this has given you, our listeners, a valuable shortcut to understanding one of the trickiest but most important nuances in negligence law.
And maybe we can leave you with a final thought to chew on. If possessing knowledge is a circumstance that shapes your duty of care, what about today's world? With instant access to expert information online about almost anything, fixing complex machines, understanding medical symptoms, you name it, has a definition of ordinary care subtly started to creep upwards for, well, maybe for everyone. Something to mull over until our next deep dive.